across the country?
That is exactly right. This is one of those moments where you cannot overstate the importance of what the Supreme Court did. In the United States of America, on June the 26th, is that today?
June 26, 2015.
2015, same-sex people have a legal right to be married couples. When you look back over the history of the United States, going back the last 50 years, 50 years ago, it was illegal in some states, including Missouri and many other states, for interracial couples to be married until 1967 in a case called Loving versus Virginia,
right,
where they said there is no good reason to prevent that. That was a huge day.
But that was a 9-0 decision.
But that was before that it was still legal to ban that. In 1954.
But it was 9-0.
That's right.
Okay. Continue on.
In Brown versus Board of Education in 1954, until then, it was legal to keep black people in schools and their kids in schools that were separate from white children.
Right.
There are historic moments, and then there are huge, incredible
Brown versus Board of Education, a 9-0 decision.
That's right.
Okay.
This case today ties up loose ends, not only for sort of the way society is evolving on the belief that same-sex couples should be married. It's up to 60-some-odd%. But what it does is it ties up the balance that privacy interests and the fundamental right to marry interest have against the idea that states and some people are uncomfortable with certain types of private activities and certain kinds of marriage. And I'll give you an example. This case is all about a case that happened 13 years ago, 12 years ago, a case called Lawrence versus Texas, written by Anthony Kennedy, who is authoring the opinion 5-4 today.
Okay.
In that 5-4 decision, it was held that a same-sex sodomy law, making it illegal for homosexuals to basically engage in their sexual behavior, was unconstitutional because of the importance of privacy concerns about what you do in your house and the government having not a good enough reason to make that illegal.
Right.
What ended up happening later or before that was the overturning of a case, Bowers versus Hardwick, where the court just 13 years earlier, 1986, when we were in high school, that said it was okay to make that type of behavior illegal.
What happens in the bedroom is subject
Stays
to
in the bedroom.
laws. Yes.
That analysis, that opinion, Lawrence versus Texas, is so important to what happened today in this Obergefell case, the same-sex marriage case.
Right.
Because what Justice Kennedy does is goes back in time to his own opinion and says, not only can you not make it illegal for people to be involved in the choice of their private behavior, but also it goes to now their decision to get married. I'll read from Lawrence versus Texas just so people know how they came to this position. There have been powerful voices to condemn homosexual conduct as immoral. The condemnation has been shaped by religious beliefs, conceptions of right and acceptable behavior, and respect for traditional family values. For many persons, these are not trivial concerns. These considerations, however, do not answer the question before us as to whether the majority may use the power of the state to enforce these views on the whole society through operation of the criminal law. Our obligation is to define the liberty of all, not to mandate our moral code. 2003. That's what happened today. This case is about privacy and about the fundamental right to live your life without government intrusion, even when a sincerely held moral code is the reason for stopping it.
This case, Scott Sherman is joining us, our legal analyst. The Supreme Court just announced in a 5-4 decision that gay marriage, same-sex marriage, is now legal, and not only legal, but protected in all 50 states, including the state of Missouri. This starts when? Doesn't it start immediately?
Right now.
Because it's been deemed the homosexual rights have been infringed upon. It's now ruled that they no longer can be infringed upon. So instantaneously, out of thin air, the constitutional amendment in Missouri is no more.
It's gone. And the idea is this, from hot off the presses less than 15 minutes ago.
Right.
Here's Justice Kennedy. There is dignity in the bond between two men or two women who seek to marry and in their autonomy to make such profound choices.
Two people right now, two same-sex couple can walk into any town hall in the state of Missouri and ask for a marriage license right now.
Not only ask for it, demand it. And say, I have a fundamental right to marry. Marriage has been deemed a fundamental right. This was Loving versus Virginia. It wasn't as though it was, say, well, it's racist against black people to prevent interracial couples from getting married. What they said is it is an assault on the institution of marriage to prevent two otherwise eligible people, two consenting adults, from wanting to spend the rest of their lives together in harmony, peace, and in privacy from the government telling them how to live their lives.
The specifics of this case was that a gay couple got married in Maryland, moved to Ohio. Ohio didn't recognize the gay marriage, and therefore that's what that was the case, right? They ruled that aren't they married even though they were married in Maryland? Even though they're not recognized in Ohio, the court said they most certainly are recognized in Ohio.
Yeah, there were a bunch of cases, including the Michigan case where they wanted to get married, and my ex-girlfriend is their lawyer. And she said, hey, this couple wants to get married. I don't know that it says about me that my ex-girlfriend got engaged to her girlfriend recently, but the idea here is profound. In Griswold, in all kinds of Eisenstadt cases about married couples wanting to have contraception, about unmarried couples wanting to have contraception. The idea of what goes on in your private life is not the government's business unless they have a legitimate governmental reason, unless they have a really good reason. That's the key. However, the technical stuff is whether or not they elevated or they looked at discrimination against homosexuals or they did it as the fundamental right to marry. Substantive due process, fundamental right to marry. That stuff is all for the legal analysts. Today, the clarion call is this. No matter whether you think you have a good moral or religious or other reason for preventing people from pursuing their private lives, you better have a DGR, a darn good reason to stop them with a governmental reason. Justice Kennedy in this court has said, no.
Gay marriage doesn't count as a reason why not to get married.
Your personal moral offense to what other people do, either in the privacy of their homes, that's Lawrence versus Texas, or what they do to get married at the courthouse steps, that's Obergefell, is none of your business.
Okay, this just came down moments ago. Justice Roberts, I don't want to say switched, but voted with the dissent. Who wrote the dissent?
Well, Justice Roberts writes the dissent in this case. Justice Thomas writes his own dissent in this case. And, of course, Justice Scalia writes his, and Justice Alito writes a concurrence to Thomas. So the other four
have their own
other
phone reasons. Now, I want to go to break. We're gonna, a lot more. We'll take a couple phone calls. But there's somebody out there right now listening to this show, Scott Sherman, who says, wait a minute. The state of Missouri voted. We went to the polls and voted in a state constitutional amendment saying that marriage is defined by a man and a woman. Why doesn't the majority of the state of Missouri carry the day? And why do 9 unelected judges who sit in Washington, D.C. trump the majority of the state of Missouri?
Is that for the break or is that for now?
Hold that thought. We'll have that answer right after this. R&R Sanitation Porta Potties. That's what I think of this decision. No, I'm kidding you. For all of you who are planning
McGraw, Scalia.
all of you are planning a 4th of July